Good afternoon, good afternoon. Thank you so much for joining us here nationwide at 5. I'm Cliff Hughes.
And I'm Siobhan Campbell.
Good afternoon, Siobhan.
Good afternoon, Sir Hughes.
Good. Well, in our cover story this afternoon, the Executive Director of Jamaicans For Justice, JFJ, Mickel Jackson, says the country may have to look at establishing a committee to review how sentences are imposed. She was reacting to a case involving a father who was sentenced to 33 years for raping, trafficking, and child pornography involving his daughter and stepdaughter.
While the organization is certainly not in support of excessive mandatory minimum, because I don't want to be misunderstood, we have called for, when we made our recommendation to the Joint Select Committee reviewing the Offences Against the Persons Act, the 3 pieces of legislation speaking to mandatory minimum, that we should have established perhaps a sentencing commission that would look at how sentences are imposed, and perhaps it's time for us to look at how we utilize consecutive versus concurrent sentencing in our country. I think it's important.
That's Mickel Jackson. She's the Executive Director of Jamaicans For Justice. Well, the St. Catherine man, a taxi driver, pleaded guilty to the offences in February this year. He was sentenced to a combined 100 years in the Home Circuit Court last Tuesday. However, the sentences will run concurrently. This means the taxi driver will serve only the longest single sentence of 33 years and 8 months before becoming eligible for parole.
In another deeply disturbing case, a 72-year-old man was convicted of raping his 3 step-grandchildren, aged 6 to 11. This comes amid news of an increase in the reports of rape incidents against children in St. Catherine and other parishes. In another case, a man was sentenced to 6 years in prison after beating fatally his 4-year-old stepson for 2 hours at different intervals for eating slowly. Ms. Jackson is urging Jamaicans to break the culture of silence and report the incidents. We're now being joined by Mickel Jackson and Chair of the Criminal Practice and Procedure Committee of the Jamaican Bar Association, Anne-Marie Furtado Richards. Good afternoon, ladies.
Good afternoon. Good afternoon, and good afternoon to your listeners as well.
Good afternoon to you both. Starting with you, Anne-Marie Furtado Richards, what exactly goes into a sentencing which distinguishes it becoming either concurrent or consecutive? Because I think a lot of Jamaicans don't understand that principle.
All right, before we go to the issue of concurrent versus consecutive, if I might be permitted to lay a little foundation in terms of the methodology of sentencing. Am I permitted to do so?
Go ahead.
Yes, ma'am.
So first of all, I'd like our listeners, and I should have said good afternoon to our listeners as well. The first thing that I'd like our listeners to know are that there are several documentations that guide sentencing in Jamaica. So we had a practice direction number 2 of 2016, advanced sentence, and we also have a sentence guidelines for use by judges of the Supreme Court of Jamaica and the Parish Court. We also can look at guidance of the Eastern Caribbean Supreme Court sentencing guidelines. All of these documents can be easily found on the Supreme Court website. So all of this is easily available to our listeners. Now, in terms of the methodology, I am going to state a case and person. With the advent of technology, it just is a simple, easy Google search. And we rely heavily on Daniel Ralston against the Queen. So the steps in terms of mythology.
Daniel Ralston?
Daniel Ralston, that is Daniel Ralston, Roulston.
Oh, Ralston, yes. Mm-hmm.
Yes, against the Queen, and that's 2018 GMCA Crim 20. So I apologize for giving too many legalese information, but it's something that they can Google if it is that they want to have that information. Mm-hmm. Now, the first thing that one has to do is to identify the sentence range. And our sentence guidelines gives us assistance as to what usual ranges can be. So if you go to the sentence guidelines, it will give you an idea of what it is that we start off in terms of a range. So, for example, in a case of murder, which I just did recently, I'm sorry, I'm just going to have to pull up my legislation, so I do apologize. The starting point, right, is from, I believe it is 15 years to life. So the range is 15 years to life imprisonment, for example, if you're looking at murder. The next thing would be to identify the appropriate starting point within that range. So, okay, we know that for murder, we have 15 years to life. You as defense counsel, and under the circumstances, you're going to make your submission to the court as to what the court could consider to be a starting point. The prosecution also has that responsibility by doing a sentence submission where they also will indicate what they think the sentence range ought to be. Of course, sometimes you might differ from between defense and the prosecution. The next step is to identify the appropriate starting point within that range, and then you consider any relevant aggravating factors. I'm so sorry. No, aggravating factors are going to be looking at whether or not the person has any previous conviction. You're going to be looking at the fact that the offense, the nature of the offense, and you're going to be looking at issues of mitigating factors as well in terms of whether or not the person is a young person, the person has never had any problems with the law. The situation is one, for example, where there was no use of force, all those kinds of mitigating factors. Now, you consider whether or not there is any issue as to whether or not there's going to be reduction for guilty plea, because you might have a circumstance where it is that the person has pleaded guilty from the offset.
Yes.
And then that segues into how it is that the court treats guilty plea. Before I go into that, I'll just continue in terms of the steps. So if it is that you have a reduction for guilty plea, then they're going to consider that. The court will then decide on the appropriate sentence, and the final point that the court will look at is to give credit for time spent in custody awaiting trial. So I believe there was a situation that Mr. Hughes, your Mr. Campbell had indicated that there was an incident yesterday. I believe that based on the calculation, the gentleman was in custody for 3 years, and that had to be factored in. So it's
Understood.
not a matter of guessing or spelling. If it is that the person spends time on custody, the case law say you must recognize. So it's a simple mathematical calculation. So I'll give an example. If it is that you started at 15 years, and then you said, okay, the aggravating factors in the circumstances, it was premeditated, there was use of violence, he's a threat to society, all of those things. Then let us say we say, okay, the aggravating factors, I will work it out to be 2 years. We have gone now 17 years. Then you look at the mitigating factors and say, okay, with all this, the situation for this person, the mitigating factors, I will calculate it at 5 years. We have gone back down to 12 years. Then now you take into consideration time spent in custody or remand on custody, and let us say that person was in custody for 2 years. You're going to subtract from the 12 this 2 years, and you're going to ultimately reach to a time for imprisonment of 10 years. So when the court follows this methodology, right, you, the accused person's attorney, as well as the victim in the matter, would be able to ascertain how it is that the judge has derived their sentence period.
So, yes, Ms. Furtado Richards, we're going back into this matter of what
concurrent versus consecutive.
Yes, what is the ultimate decider in that?
Okay, so concurrent for our listeners, it means it's an event or action that occur at the same time. Versus consecutive, it means that you have an incident that is one after the other in a sequence. Now, there's another case I'm going to quote, and again, as I said, it's a Court of Appeal decision from as far back as 2011 that went into detail as to what is the difference between a concurrent or consecutive sentence. Now, and that is the case of the Queen against Kirk Mitchell, 2011 JMCA Crime 1. Simply put, concurrent, these are where offenses were all committed in the course of the same transaction. So, for example, let us say someone committed an offense using a legal possession of gun, right?
Yes.
And so they use a gun to commit a robbery or even to also to shoot and wound someone. So in the old days, that person would have been charged for illegal possession of firearm, wounding with intent, and robbery with aggravation. Now the person is going to be in the possession of a prohibited weapon. So all of that happened on one occasion, and the person has been found guilty and is going to be sentenced. That sentence invariably will run, each count will run concurrent to each other. So let us say the illegal possession of firearm, the person got 15 years, then the robbery with aggravation, the person got 20 years. Let us say the wounding, it was so egregious, they gave them 30 years. Then we know that person will be in custody using the larger sentence of the 30 years.
Interesting. So the heinous nature of the crime does not have any impact on this? The heinous nature of the crime does not have an impact on whether it is concurrent or consecutive. It's simply a matter of the cases being essentially being done at the same time?
Well, let me go on to say that the consecutive, as I said, is something that runs after the other. However, if it is so egregious that, let us say, a consecutive sentence is being considered, there is a principle called the totality principle, which means the aggregate of the sentence should not substantially exceed the normal level of the sentencing for the most serious of the offenses involved. So let us say, for example, you got, let us say, wounding with intent and the legal possession of firearm. I don't have my guidelines in front of me, so I can't tell you. I'm just going to pick a figure. But let us say the wounding, normally, let me not use wounding because wounding can go up to life. But let us say it's an offense that has a determined period. That means it has a fixed period, 15 years. And the other offense has, let us say, 10 years, but you want to do consecutive. What the cases are saying is that you still have to look at the totality of the offenses and not exceed what the maximum sentence of the offense would be. So we're not saying that there might not be circumstances where the court thinks that you cannot impose a consecutive sentence. So we will say that you can, but it would have to be a very egregious set of circumstances, and the court would have to indicate the reasons for not imposing the usual concurrent but consecutive sentence. Because remember, the DPP pursuant to the amendment that was done to the Judicial Appellate Jurisdiction as well as the Judicial Parish Court Act has the power to appeal a sentence if it is that it is felt that it's not adequate or it's unduly lenient. Likewise, the now convicted person has similar powers or rights to appeal if it is viewed that his sentence is manifestly excessive.
I think we have to bring in Mickel Jackson here. Mickel Jackson, the commission that you are proposing, yes? Tell me, what would you want to be their terms of reference?
Good afternoon again. I'm happy that council went through all of those explanations because it's important that the public really understands what exists in terms of the sentencing guidelines and what exactly we've been calling for, because proportionality is key. And I'm also happy that council also explained the totality principle, because when you look at the recent case, that is something that jumped out at me, given that rape has a maximum term of life, and I considered whether or not in this particular context where trafficking and those other offenses the person was convicted, whether or not consecutive perhaps would have been appropriate. Just from an organization and a personal perspective, it's something that we were looking at as well, which is why from JFJ, sentencing has to be proportional, it has to be fair, and there must be justice realized. It's not just reacting to public outcry. And it's on that basis that JFJ had called for two things. One, should there be a revision of the sentencing guidelines? Because we're happy to have it, but when you look at the Eastern Caribbean and also the United Kingdom, their sentencing guidelines, it's a little bit more detailed, very offense-driven, wherein when you look at every single offense, serious offenses that is, you can get a sense. If I look at murder, these are the specific aggravating and mitigating factors that ought to be considered. Should I have that? Not necessarily to ensure that there's uniformity alone, so that the public can pick up a document and fully appreciate what exactly goes into a sentence or sentencing process. That's one. The second thing that we had called for is perhaps a sentencing council, similar to what exists in the United Kingdom, or a sentencing commission, similar to what exists in the United States, and it varies per country. I'm told that Jamaica has an advisory committee, but should we have a body that is established by law, that we appreciate that this is their mandate, to have the JAMBAR, the DPP, private attorneys, the judges would be chairing that council. I'm just speaking off the top of my head. It's something that we would need to really think about a little bit more, what works for us. Get proper funding, and they appreciate that this is their mandate to perhaps make recommendations to the legislator about changes that they believe collectively ought to be considered. Do research based on how sentences are being imposed. Do the public education. So when you hear the representative from Jambai speaking, you get a sense of what goes into sentencing. Should we have something by law that does all of what we're even discussing today? So the public is not saying that this is what the judges are doing. The judges are not sensitive to what is happening, but we can appreciate that sentencing ought to be fair and it ought to be just. But I think it needs some proper revision and funding to go into this type of structure. And why is it important as well? We don't want sometimes parliamentarians who are also political actors, members of parliament, reacting only to the outcry when they go to their constituents. You want sentencing to be guided by data, to be guided by the research. So we understand, again, there's uniformity. The victims are being considered, but you don't want a piecemeal approach where sometimes you inflate the sentences for some offenses. For example, the firearm provision we saw recently with the revised legislation versus others when it comes to rape and so on. What is appropriate based on the circumstances, which is why JFJ made that proposal.
And I have to put back on to you, Miss Richards of the Bar Association. Explain to the public who are asking questions about that man who was sentenced to only 6 years in prison after battering his 4-year-old stepson for more than 2 hours and end up given only 6 years in prison. What could explain that?
So again, I'm going to say all of these are my opinion because it is that Mr. Hughes, you would know the short notice.
Yes, yes.
That was given to me.
Sure.
All right. So I really don't know the case on hand that you speak about. I only got a quick research to find out about it. So I can't tell you what the case is, but just having heard what you say, I can say to you the following. I understand the person pleaded guilty. And remember, I had alluded to the fact that legislation provides for...
He pleaded guilty for manslaughter on the lesser of the two charges.
Right, because remember, murder comes with a component of mens rea in terms of you had an intention.
To kill.
Right? And so it could be argued, although you're saying to me 2 hours, I don't know as a fact that it was for so long. And even if it is so, the question is going to be that the Crown would have to have seen something about the case to suggest that there was not an intention to kill this child. Because remember, murder is you're either going to kill the person, you had the intention to kill the person, or to seriously harm the child, or to seriously harm the person. So we always say, like, for example, for a gun offense, if it is that you use a gun to shoot at someone, then a gun is not going to ricochet off someone. The intention must be either to kill the person or to cause serious bodily harm. Isn't that so?
Yes.
So for me, I can't speak to why manslaughter was offered. Obviously, the Crown, or it is because you might have a case where the Crown's case does not suggest manslaughter, but the defendant's case puts manslaughter to the court, and the court can when someone is pleading guilty, and there's a case called Perlino Wright, accept the version that is most favorable to the accused. So I don't know the circumstances that allowed a manslaughter plea to be offered, but it had to be something that the Crown, the defense, and the court had to be in agreement with, because the Crown can say, okay, I'll accept a manslaughter plea, but if it is that the court does not agree with that posture, the judge can say, I will not accept that plea, and we will have to go to a trial for the jury to decide whether or not manslaughter is going to be suffered. Having passed that, remember the
to
person
jump in
has to
there,
be guilty.
I think it's important, all of those factors that you just mentioned, that the public appreciates it. And, I just want to impress upon the media practitioners that these are the things that should go into a story when you're writing the report. Because otherwise, the public is just going to jump up and say, 6 years for something so egregious, perhaps not appreciating all of the factors around intent and how you separate and differentiate between manslaughter versus murder and so on. So I think those are the things that I mean it's important for public education and transparency.
Okay, understood.
And so the legislation, you have the Criminal Justice Administration Act, as well as the Offences Against the Persons Act, that talks about the discounts. I think a lot of us have heard about it. Under the Criminal Justice Admin Act, 50% is given at the first relevant date. So if it is at the first opportunity, the accused person said, I am guilty. I'm not going to waste the court's time. I am not the family. I am devastated. The family, I don't want to cause any more problems. I am here pleading guilty. He gets 50% consideration because the court don't have to necessarily automatically give him the 50%. Then, if it is that he pleads after the relevant date, but before the trial commences, he gets 35% discount.
Okay.
If it is that the trial starts, but before the verdict, he gets only a 15% discount. Now, if it's an offense under the Offences Against the Persons Act, if the persons plead versus the Criminal Justice Admin Act, he only gets, and I'm going to say he, as in it could be he or she. So I don't want anyone to cuss me about being gender biased. So it's 33 and 1/3% if it is that the person pleads at the first relevant date, 25% if after the relevant date but before the trial starts, and 15% if the trial has started but before verdict. So you're going to, that might also be taken into consideration, right? You also remember I told about aggravating circumstances and mitigating circumstances. All of those are going to be put. So it's going to be, you add the aggravating, it's a child, the way in which the person died, then you're going to subtract mitigating. Suppose it is that this person has never been in the trouble with the law. So the person has an unblemished record, and he comes with character witness to say, he's a good church person. We don't know. We're not saying that he didn't do it, and we don't know the person that we know. We are so surprised. The court is going to subtract those mitigating factors. As I said, I was advised that he spent 3 years in custody. So that 3 years in custody must be deducted. So when you do all of those addition of numbers, subtraction of numbers, you are going to get the ultimate number of 6 years. So when persons hear 6 years for the murder of a child, it is not as simple as that. There is thought process involved in the process. Right?
Got you. We got to leave it there. Thank
Yes,
you very
I'm
much,
sorry.
Counsel. Yes?
Yes.
Very much. You were very helpful in getting us to understand the intricacies of sentencing. Anne-Marie Furtado Richards, she is the chair of the Criminal Practice and Procedure Committee of the Bar Association, and Mickel Jackson is the executive director of Jamaicans for Justice. Thank you, ladies.